Hi, a warm welcome all of you. I'm Kamni Mascara, Assistant Planner Head at Dilzer Consultants. We thank and appreciate everyone for attending this Will and State webinar today. While we wait for our final few attendees to join in, let me introduce Dilzer Consultants to you. We are a 24 years old, Bangalore-based, SEBI-registered investment advisory firm. Our director is Mrs. Dilshad Bilimoria. We provide financial services including wealth management and financial planning services. Allow me to familiarize you with the tool that we are using today. It is Zoho CRM. There's a question and answer box down below. We welcome all your questions in the box, which we'll address at the end of the webinar. Thank you. Let us begin. Over to you, Komal.
Thank you, Kamni. While we wait for all the attendees to attend, let's go through our video of Dilzer Consultant Services, and we will be back in 2 minutes. Thank you. Good morning, everyone. I welcome everyone. And today with us, we have Suresh here as a guest speaker. Mr. Suresh K, who is a qualified paralegal as well as estate planner. Along with that, he is also a certified financial planner with over 30 years of experience and expertise in finance, personal finance, including estate and succession planning, investment, insurance, and tax planning. Welcome, Suresh, to our seminar.
Hi, welcome.
Hello.
Good afternoon, everyone.
Alright. So, Suresh, let's start our webinar now, and let's start with the basic understanding of will and trust. Can you tell me
Sorry,
what?
Komal. Komal, I'm sorry, there is a echo of the voice.
All right, let me fix that.
With two
Is
speakers
this better
closely.
now? Is this better, Suresh?
Yeah, better now. Oh, please go ahead.
All right. Can you tell me what is the difference between a will and a trust?
The question is, what is the difference between will and the trust?
Yes, that's true.
So, will is a legal document that enables a person to make a provisions for the bequeathment of his assets after his life. Okay, so will takes effect only after the demise of the person. It is primarily for the transfer of properties. Whereas a trust is an instrument or an entity that holds the assets, manages the assets for the benefit of the persons known as beneficiaries. So the primary objective of trust is to protect the assets for the benefit of beneficiaries. So will is for the transfer of assets, whereas trust is for the protection of the assets.
All right. Okay, so my next question is when does one need a will and when is creating a trust essential?
Okay. So when one needs a will or when one needs a trust, when a person is very clear that his assets when transferred to the legal head beneficiaries, where they can manage it for their use or benefit, then will would suffice. Say, for example, I want to transfer all my assets after my life to my sons, who are major, of course, married, they have their own family and children responsible in their life. So my job is simple, just after my life, pass on the assets to them. A will would suffice.
Okay.
Suppose if my children are minor, even if I pass on the asset, they doesn't have a capacity to manage. In such case, we recommend to set up a trust. So underlying point is that when a person or beneficiaries themselves does not have a capacity to manage the assets, then we recommend to set up a trust.
Okay. Moving on. What happens if a person deceases or passes away without a will or a trust?
So when a person passes without a will or a trust, in legally we call it as intestate. Okay, a person dies without any planning, it is known as intestate. So when a person dies intestate, the succession laws will determine the legal heirs who have a rights of inheritance. And we have different succession laws upon the religion. So where Hindu Succession Act, it applies to Hindus, Buddhists, Sikhs, and Jains. We have Indian Succession Act, which applies to Christians and the couple who belong to a different religion, and Muslim personal law for Muslims. So each of these laws have made provision identifying the legal heirs who have a right of inheritance. So these legal heirs will inherit the assets of the deceased person in the event of intestate.
All right. So, after that, I would also like to know how often should a person update or review their will or trust?
So in case of will, normally we make the will considering the present circumstances, life stages, and other important factors which we can foresee in the near future. So whenever there are any changes in the circumstances or factors that are considered in making a will, so it is a time to review and make the changes to the will. Whereas a trust is a document, that remains more or less same unless there is a death of beneficiary or the assets of the trust are exhausted, where it warrants a dissolution of trust. Otherwise, the rules and regulations that govern the trust remains in force throughout.
Okay. The next question is what are the legal requirements for a valid will in our state like Karnataka and our country, India?
The legal requirements for valid will is first thing that the person who is making a will, what we call testator, must have a capacity to make a will. That means he must be a major, above 18 years, and must be of sound mind, and not under influence of any substances or other narcotics at the time of making a will. Okay. So next is the person who is making a will, testator, must be identified very clearly without any ambiguity in the will. So name of the person, his father's or husband's name, age, address, and also reference to any ID proof like Aadhaar, PAN, passport. It is also important to identify in the similar way all the members of the family or legal heirs to whom the testator wishes to bequeath his assets. So beneficiaries are also very clearly identified with the ambiguity. And also list the details, assets with all the relevant details so that it can be clearly identified. So let us say instead of saying all my bank accounts, so better to give the account number, bank and branch. Instead of saying all the properties, it is recommended with the address of the property and also if possible with registration details of the document. So these are the points which make the will valid. And also, I also recommend strongly to appoint an executor in the will. And will must be signed by the testator at the bottom of each and every page. And will must be attested by the two witnesses. So these are the various requirements to make the will valid. Whether it is in Karnataka or in India anyway.
All right. Okay. Can one person create a will or trust online, or should they hire a lawyer for that?
A will can be drafted by any person. Even a testator can draft himself. We can take support of any professionals, online platforms.
Okay.
Ultimately, the bottom line is that the will must capture all the relevant information like what I discussed earlier and ensure that it is properly executed so that it stands valid.
Okay. Next question would be what documentation and information does a one person need before starting this process?
Before starting to make a will, like I discussed, whatever information about the details of the testator, details of the beneficiaries, details of the executor, details of the witness, details of all the assets should be in one place, so that all this we can incorporate in the will. Okay. So to enable the clients, it is better to go with a professional who may help the client to have a standard format to capture all these details without exclusion of any other asset.
All right. How does one include charitable donations or causes in their will?
Yes, definitely we can add a clause in the will for a charitable purpose apart from bequeathing to the family members or other legal heads. So it is very important to identify the cause, charitable cause, and also the institute to whom the testator would like to bequeath. So again, the purpose of making a will is to give a clarity. To give a clarity about your wishes around the charity and also the institute and the purpose for which you are giving, and accordingly it can be read with the by the professional who is drafting it.
All right. What happens to jointly owned properties after the demise of the person who creates the will or a trust?
Yeah, good question. So generally people think that when the property is jointly owned, on the demise of a one owner, the people think that the other surviving owner will become the absolute owner of the asset. It is wrong legally. Okay. In the absence of will, when the property is a joint will, if any one owner dies, the surviving does not become the absolute owner. The share of the deceased owner will pass on to his or her legal heirs. So, to pass on the share of the person or a co-owner, it is better to make a will and bequeath his share in the property to the surviving or the other co-owner.
Okay. So my last question for this segment is, what are the common mistakes people make while writing a will?
The common mistakes is number one, not using language with clarity. So when the will is drafted by a person himself without the support of any professional, so normally we come across conflict statements. So very difficult to arrive at the intent of the test. So these are common mistake we come across. Number two, not appointing an executor in the will, which becomes very important in case of any disputes or other issues. Okay, and also not identifying the beneficiaries adequately, and also the property. These are the common mistakes.
I see. Okay. And before I ask Kamini to take the next segment, I just wanted to announce and let all the audience know that there is a question answer uh, part over here wherein you can go and post your questions if you have, and all the questions will be addressed at the end of the webinar. We'll collectively go through because we have different segments and most of the questions might be answered during the webinar. All right, over to you, Kamini.
Thank you, Komal, for general understanding of will and trust. Now, let us proceed with our next segment, property and financial accounts. So, yeah, Mr. Suresh, should a person include his house, vehicles, and gold belongings in his will?
Sorry, you said gold before that?
Vehicle, house, and
Vehicle.
gold belongings. Vehicles, yeah.
Of course, all these are all assets held by the person. It is very important to include the house property when we make a will. In fact, we always recommend when a person holds a property, it is a must for him to make a will to ensure seamless transfer of assets. So it is also equally important to include the vehicle also, because the ownership of the vehicle is maintained by the government authorities, what we call registering authority, RTO, road transport authorities. So on the demise of the owner of the vehicle, it is necessary to change the ownership on the vehicle, and the owner of the vehicle should give clear direction who will have the rights for the change of ownership. So please include vehicle also, either two-wheeler or four-wheeler. So in the absence of will or proper direction, sometimes the cost of updating the ownership could be more than the value of the vehicle.
Right.
So also I strongly recommend to include gold and other assets to give clarity to the legal.
Right. So, yeah, let's move to our next question in the same segment. How will one handle assets like investments, insurance, retirement accounts, and also foreign asset for that matter?
So first I take foreign assets. You may include foreign assets in the will made in India, but this does not have any legal significance. So we strongly recommend to have a estate planning separately and independently for the assets which are in different countries. Okay. So coming to insurance and other financial assets also should be included in the will by giving the policy numbers and the company which has issued the policy. So though we make a nominations, again always there is an ambiguity whether the nominee becomes absolute beneficiary of this insurance amount. So will is an instrument that can give clarity. So if you wish to give insurance policy money to a nominee named in the policy, so reiterate by mentioning in the will that the said nominee will become the absolute beneficiary.
Right. Okay, let's move to our next question. And similar is the case with insurance and retirement accounts?
Yeah, of course. All financial assets for that matter, including mutual funds, demat accounts.
Okay.
So will is the last wish made by the person.
Okay, makes sense. Yeah, so another question would be, What is the difference between naming a beneficiary in an account versus listing it in a will?
Naming a beneficiary in the
Account
account. So
versus
naming a
listing it in a
beneficiary
will.
is in India we call it as a nominee.
Okay.
Okay, maybe in other countries, US, beneficiary in India is a nominee. So we are aware that in India the rules of nomination very clearly states that nominee is only a custodian or a person authorized to receive the funds or money on behalf of the legal heirs or the beneficiary named in the will. Nominee does not become the absolute beneficiary of this money by virtue of nomination. So nomination is not a tool or instrument to transfer the title over the assets or benefit of the assets. So it is a beneficiary in the will who have rights over this money.
So it is always
So though
advisable
nomination is
to.
made, I strongly recommend to make the person beneficiary in the will.
Right, right, makes sense. Okay. So another question, does the person need to include his digital assets like emails, passwords, crypto,
Yes.
etc.?
It is very important to give authority to one person who will have a control over all the digital assets of the deceased person. Today, email and mobile number is very important for management of all our investments and other assets. So all the transactions can be done only through the OTP, which are normally sent to mobile and the email. So it becomes very important to give access to a person who will have a right to manage these assets.
Right. So here goes my last question of the segment. How can one protect his business or professional assets through a trust?
Okay. So when we talk about business, it could be either a proprietorship or a partnership or a company. So proprietor and individual is a, they are not two entities in law. So when a person is doing a proprietorship business, there could be business receivables and payables. So it is very important to include details of this proprietorship business and also make a provision how any dues to be paid by the proprietorship can be paid out of the assets, or who will have a right to receive the dues to the proprietorship firm. So that there is a clarity for the person who owes the money to the proprietorship firm to whom he can pay this. It is important. So when you come to the partnership firm, it is an agreement between the partners. So we have to see the clauses in the partnership agreement about what happens on the demise of the partner. What are the provisions made? So depending upon the provisions made in the partnership firm, we have to factor those in the will and make appropriate provisions. Say, for example, if the partnership firm states that on the demise of one partner, the other partner shall continue as a partners, and the share of the deceased partner will pass on to their legal heirs in terms of compensation. Okay, then clearly in the will it must be mentioned that who are the legal heirs who are engaged in the partnership firm, or who is a legal heir who will represent the deceased in the partnership firm.
Right.
Okay. So these are the factors we need to consider while making a will to protect. So in case of company which is unlisted, where the deceased person is holding the shares, so that also we have to make a provision and identify a beneficiary who will have the inheritance of this unlisted shares, so that he represents a company as a shareholder.
Right.
The beneficiary, so neighbor will represent the company as a shareholder.
Right. So yeah, over to you, Poma. Next segment.
Thank you, Gamni. So our next segment is dependence and guardianship. So Suresh, please tell me, how do I name a guardian for my minor child or children or dependents?
I'm sorry, I could not clarity. Can you just repeat?
Sure. So how do one person name a guardian for their minor child or dependents, like parents or minor kids?
So it's a very important point we need to look into while making a will. So as long as any parent is alive, as parents will be the natural guardians, no one can replace them as a guardian. But there could be scenario where parents have been necessarily minor. So in such cases, it is better to in the will and appoint a guardian. Okay. The role of guardian arises only in the parent the child is minor. So who can be a guardian? Any family member who loves the child, where the parents have a confidence that the guardian will look after the personal welfare and well-being of the child. So this guardian can be appointed when the person makes a will. So this process is known as testamentary guardian. So will is a testamentary document, and the guardian appointed in terms of will is known as testamentary guardian. So in the absence of appointment of testamentary guardian, the person who is interested to look after the child must oppose the court and himself appointed as a guardian. We call them as a legal guardian. It is a very complex and cumbersome process. So when the parents who have a minor child making a will, so please keep in mind it is also important to name the testamentary guardian. So this guardian will have an authority to look after the personal welfare and well-being of the child, and also we can give an authority to look after the estate or assets of the minor child. The assets will be held in the name of the minor child, but the operation will be in control of the guardian. And when the child completes 18 years of age, he will become the absolute owner and also have an authority to manage the assets. So guardian will have no role once the child completes the age of majority.
Interesting. All right. Can one person specify how their kids' inheritance is going to be managed until they become adults?
Once the assets are bequeathed to the child who is a minor, and once he attains the age of majority, he will have absolute right over the money. Okay. So if the parents wish that the child should have authority or complete control over the asset only after a certain age, not at the age of majority, 18 years, then it is recommended to make a provision to set up the trust. Okay, and if the child does not complete age, let us say age 25 years, that must be age 25 years. Okay, so if the child is less than 25 years and on the domains of the parents, instead of all the assets getting transferred to the child, it gets bequeathed to the trust. And trustees manage these assets for the benefit of the child. And child completing the certain defined age, the trust will get dissolved and all the assets will get transferred to the child. So in that way, we can protect the assets for a certain period till the child has enough maturity and ability to manage the asset. That is what I said, trust is for the protection of the assets.
True. Interesting. Okay. Next question is, can a trust help provide for a child with special needs?
Yeah, definitely. We strongly recommend to the parents who have a child with special needs to set up a trust for the benefit of the child. So during the lifetime of the parents, they can take care of the needs of the child. So the question arises on the demise of the parents. So who will look after the assets for the benefit of special needs child? Who will have a right to hold these assets? So trust is an instrument that enables the parents to pass on the title to the trust and make provisions that the trust fund shall utilize it for the benefit of the special needs child. So the advantage here is that the assets are not held in the name of the individual. The assets is in the name of the trust. So one person cannot take a call about the management of assets. So there is a overseeing of the trust board of trustees about the management of the assets.
Okay. All right. My last question is for this segment. What happens if a guardian, I decide or dedicate, is unable or unwilling to serve that child?
So when you appoint a guardian,
Hmm.
you are giving a responsibility to. So it is strongly recommended that when you name a person as a guardian, please have a word with him, talk to him that he has been appointed as a guardian, or you wish to appoint him as a guardian, and take his concerns and appoint him. So to this, when we do this, to great extent, this situation will be avoided. But in spite of that, there could be circumstances where guardian is unwilling to act, or he doesn't have something, he has certain constraints to act. To overcome such kind of situations, we always recommend to have a successive guardian. Okay. If guardian A fails to take the responsibility, then the guardian B will step in. Even if guardian B fails in, guardian C will step in.
Is there any timeline or any rule or anything that defines that process?
Yeah, we can mention that if the guardian does not take up the responsibility within 3 months from his test, within 3 months of the date of the testator,
Okay.
then the successive guardian will step in. 3 months, 1 month, it depends.
Alright. That was the last question for dependence and guardianship segment. Over to you, Tama.
Yeah, thank you, Komal. Once again, I request all the attendees to post your questions in the question and answer box, which we'll address towards the end. So yeah, the next segment is executors and trustees. So who should a person choose as executor or trustee?
The executor arises in case of will. So executor becomes the legal representative of the deceased person. So when I make a will and appoint Mr. A as an executor, so I am giving him the responsibility to implement all the provisions that I made in the will. So effectively he becomes my representative. So this person can be anyone on whom the testator has a trust, has a confidence that he will implement the provisions made in the will. So the executor can be any one of the family member or beneficiary also, or executor can be any third party. So depending upon the relationships among the family and the volume of estate and other factors, we can take a call whether a family member can be an executor or a third party or outside parties.
Okay. So my next question was, can executor or trustee also be a beneficiary? Which you cleared, they can be a beneficiary.
Executor of the will also can be a beneficiary. Absolutely, there is no restrictions by law. But the law very clearly says that if the executor does not take responsibility of executing the will, then he shall not claim any benefits under
To safeguard the interest, right?
to safeguard the interest of other beneficiaries.
Right. Makes sense.
Right. So it is like, I've been given responsibility as an executor, and I don't want to take responsibility, but I want only benefits that are given under the will, which is not fair for the other beneficiary.
Right.
As I said, executive is a legal representative of the deceased. He has been given responsibility to distribute the assets as per the provisions made in the will. Okay.
Right. Okay, so what responsibilities do they have? What kind of? Can you
So
just throw some light?
executor can collect all the assets of the deceased testator. He can also collect any dues of money to the testator. And then wherever he has to execute certain documents for the distribution of assets, he can do. Even if necessary, executor can redeem or sell certain assets to implement the wishes of the testator. That's what he said. He becomes a legal representative. He steps in the place of the deceased.
Okay, sure. So, like we have successive guardian. So, should a person appoint a backup or alternate executor or trustee if the original one doesn't make it or if he's not available?
Yes, I strongly recommend to appoint even successor executor like guardian. Okay. Sometimes even the executor who is so appointed would have died before the testator's death. Okay. Then again, testator has to update the will, make a amendments to the will. So instead, we can make a provision for the successor executor.
Often that has to be done, or it's total discretionary.
Correct.
Or there's a like every time, or it's total at the discretion of the person who is making will.
Person who is making a will, he can decide.
Okay, sure, sir. So the last question of this segment would be, how can a person ensure that they act in beneficiary's best interest?
So when we appointed trustees to manage the assets of the trust, primarily we believe in them, we trust in them. So we need to appoint such persons on whom we have a trust. That we call them as a trustees.
Right.
But we are all human beings. So always there could be change in the thoughts of the trustees and behavior. So many other factors may influence their behavior. So yeah, we also can make certain provisions to safeguard the interests of the beneficiary. So generally, we recommend that the trust accounts must be audited at the end of every financial year by the qualified chartered accountant. To ensure that all the expenses that are or the objectives of the trust.
Right.
Apart from that, I also recommend to have at least 3 trustees in case of private trust, so that one person does not take decisions.
Collective decision making.
It's a collective decision making.
Makes sense.
So it also helps in the continuation of a trust, because if you have only one trustee and the demise or incapacity of such trustee, then again there will be a vacancy of the trustee. So it is better to have at least 3 trustees, so that in the event of demise or incapacity of one trustee, there are other 2 trustees to continue.
Right.
Why 3 trustees? If you have only 2, there could be difference of opinion in decision making. So when you have trustees, 2:1 majority will take.
Right.
So these are the provisions we can consider to safeguard the interest of the beneficiaries of the trust.
Right. Sure, sir. Thank you for this segment. Yeah, over to you, Komal.
Thank you, Kamini. So our next segment is trust specific questions. My first question would be, what are the main type of trust?
Trust can be classified on different parameters.
Okay.
So one of the classification is a trust can be for a charitable purpose or it can be a private trust. So when the trust is set up to provide some benefits to the society in large, okay, we call it as a charitable purpose. So here the beneficiaries are not identified. So beneficiaries are the members of the public and the society who fulfill certain criteria to receive the benefit of the trust. Okay. Whereas when you say private trust, it is not for a charitable purpose. It is for the benefit of specific people who are identified. So it can be for my family members. In such case, I call it as a family trust. So a trust broadly can be a charitable trust or a private trust. So why I took up this is that generally when we tell the client to set up, I think it is for the charitable always. Okay. A trust also can be set up for the family, for the benefit of family, what is known as family trust. So next classification is a revocable or irrevocable trust.
Right.
A revocable trust will give the authority to the grantor of the trust to revoke or cancel the trust and take back all the assets of the trust. This is known as revocable. Whereas irrevocable trust does not give authority to the grantor to revoke and take back the assets. Once it is set up, it continues provisions for dissolution are fulfilled. So by default, or charitable trust or irrevocable trust, the grantor will not have an authority to revoke. Whereas private trust can be set up as revocable or irrevocable trust. Then third classification is depending upon the number of beneficiaries of the trust. A trust can be a determinate trust or a discretionary trust. So when there are more than one beneficiary and the share of each beneficiary in the trust property and trust income is determined or specified in the trust deed, such trust is known as determinate because the share of each beneficiary is determined. So when the share of each beneficiary is not determined, then the trustees will have discretionary to use the trust fund in income for the benefit of beneficiaries. Such trust is known as discretionary trust. So these are the various classifications people use.
Okay. So next question is, what are the advantages of creating a trust?
The primary benefits of creation of trust is to protect the assets for the benefit of beneficiaries. So trust can be created for the benefit of minor children who doesn't have a capacity to manage, again for the benefit of the special needs child who doesn't have a capacity to manage, even for the benefit of the daughter going to getting married, so that the assets of transferring to the daughter is held in the trust. In fact, today it is other way around also. Don't mistake me. Many young men are coming to me before they marriage to set up a trust, and all the assets are setting up, transferring to the trust before getting married. So, in case of any disturbance in the marriage, disputes in the marriage, their assets are protected. Even trust can be set up for the benefit of the parents who are senior citizens or any other person who are senior citizens where themselves are not capable of managing their assets. So these are the various situations we look after to set up the trust. Even if trust can be set up by the business people like partners in the business or a proprietorship firm or the professionals, so where the liability out of their business or profession can be unlimited. Even personal assets can be attached. So to protect some of their assets for the benefit of family members, a trust can be set up.
Good to know. Okay. The next question is, how does a trust help avoid probate?
The probate is necessary only when the will is executed.
Okay.
Trust does not require probate. Okay. It arises only in terms when will is executed.
I see. Okay. Can one person change or dissolve a trust later once it is formed?
Uh, we need to look into the provisions made in the trust deed. If there are any conditions that gives or empowers the grantor of the trust or the trustees of the trust to change the rules of the trust, yes, it can be. Otherwise, no.
Okay. All right. Who controls the assets in the trust during a person's lifetime?
Sorry, I could not get your question.
Who controls the assets which are involved within the trust
All
during
the
a
assets,
person's lifetime?
all the assets of the trust will be in the control and management of the trustees. That is the role of the trustee. The income that arises or the trust fund as and when needed can be used for the benefit of beneficiaries by the trustees. But the control and management of the assets will be with the trustee.
Okay. All right. Um, how are the trust taxed? Is there any tax provisions, advantages, or anything which we have to keep in mind?
How?
How are trust taxed? How does the taxation?
Tax, okay, income tax. the tax of the on the income of the trust depends upon whether it's charitable or a private trust. Okay. So let us take up only private trust for discussion for now. So the income tax rules for a private trust depends upon whether it's a determinate trust or a discretionary trust. In case of determinate trust, of each beneficiary is determined, and the income of the trust will get distributed as per the share of each beneficiary. So it is treated as income of the beneficiary and will be subject to tax at the slab rates applicable to such beneficiary. When the trust is discretionary trust, the income of trust will be charged at the maximum marginal rate. Okay.
So my last question for this segment is, can a trust protect assets from creditors or lawsuits?
Can the trust get the assets?
Can a trust protect the assets from creditors or lawsuits?
See, normally we recommend the trust to protect assets of the creditors of the business or professionals. But it all depends upon when the trust gets set up. With the clear indication that the trust is being set up after the losses in the business or forceful commitments to avoid the payment to the creditors, courts make it depends upon the business. But generally, when the trust is set up much earlier than all these situations have arisen, so assets are generally protected. It's like insurance. When we don't need it, you feel when you don't need it, better to set up and protect your assets.
All right. Okay. So that was it for the session 1. Now we are going to move to questions and answers from the audience. Over to you, Dhamma.
Yeah, thank you, Komal. So let us look at the questions from the question and answer box. Yeah. The very first question is, what happens to an unmarried woman who dies intestate?
When a woman who is unmarried dies intestate, the first step is to determine the religion of the deceased woman.
Religion?
Of the deceased woman.
Okay.
Because when a person dies intestate, as I said, the succession laws will determine the legal heirs who have rights of inheritance.
Okay.
And the succession laws depends upon the religion of the person.
Right. Accordingly, it will be
for
taken
example,
care.
if the deceased woman is a Hindu and dies intestate, assuming she is married, having husband and children, so the rights on her assets will pass on to husband and children, and all the assets which is self-acquired by her.
Okay. And assuming
any
she's
asset
not
which she
married,
has, which she has inherited from her parents on the demise, only children will have a right, not the husband.
and what if she is not married, sir, and she is a Hindu woman and
If the woman is not married, then it will go to the father.
Father?
In the absence of father, mother. If
Or
both the
maybe
parents are not alive, brothers and sisters.
Okay. Okay.
This is only for the Hindus.
Yeah. Religion
So
depends
if we
upon
talk
the
about
religion.
Christians, if the woman is married, 1/3 will go to the husband. Okay.
Right. Makes
If she
sense.
is not married, first all the go to the father. In the absence of father, then to the mother.
Okay. Sure. Another question from the question and answer box. So can you throw some light on the registration of the will? Does an unregistered will hold valid? Are unregistered wills, does it have any validity, or are they held valid, or how? What is the registration of the will? How?
Registration of will as per the law is optional. Okay. But in practice, if the will is not registered, it is difficult to accept to prove the validity of the will. So law is given only an option to register or not. Whether option is given, it is always better to go with the right option. So I strongly recommend register the will in the office of the sub-registrar. So when the will gets registered, the identity of the person or the testator is proven. His fingerprints, his photographs are obtained on the back of the will. Two witnesses have signed and it is executed in the government office. So it gives a layer of authenticity to the will, which is difficult to dispute.
Okay. So it's always advisable to get your will registered.
Yes, yes.
Right, right. So another question that we'll discuss at the end, post the webinar, we'll be sending the details to the attendees. Yeah. So does will supersede nominee? You have already touched upon points,
Yes.
but yeah, does will supersede nominee?
Yes, will supersedes nominee.
Okay. So it's always good that, yeah, you should have a will in place with a beneficiary there, right?
Yes.
Right. Another question, what are the laws of intestate for Hindus, Muslim, Christians, and others in terms of distribution of assets according to the law?
It's a very big subject. So many
Right.
factors we're looking into it again depend upon the religion. Hindu
Right.
Succession Act, Indian Succession Act, whereas Hindu Succession Act for male and female is different. We have a separate session for this.
Right. Yeah. And we are going to have a second session wherein we'll cover these topics. Last question from the question and answer box. Do prenup agreements need to form part of a will that we have before marriage, the prenup agreement between the spouse and the families?
Yeah, if there are any clauses in the prenup agreement that the transfer of assets held by the person, better to make a mention in that.
It's good that we mention.
It's only for the information.
Okay.
Agreement is only for the bequeathment of assets. But if the prenup agreement affects the bequeathment, better to give an explanation.
Sure. These were the questions in the. Okay, is prenup legal in India? There is another question that has come.
And as of now, I have not come across legally where it is accepted.
Right. Okay. So yeah, that's about it from the question and answer segment. So thank you, sir, for this. Let me just summarize the entire session. So we learned about state and will planning, as well as how and why it is crucial when someone has assets and wants to divide them according to his will. Difference between will and trust, guidance on legal requirements, clarification on how assets are being managed, process of naming a guardian for minor, identifying roles and responsibilities of executor and trustees. In short, we have covered what, why, who, and how of comprehensive state and will planning. And moving ahead, at last, our call to action would be state planning is not just legal or financial, it is deeply personal. You don't have to carry the burden alone. Seek guidance, make informed choices, and take just one step today. That single step can give your family peace that lasts a lifetime. Hence, interested ones can reach out to us, and the details will be shared post webinar with all the attendees. Right? And yeah, and now let's move ahead. Also, requesting all the attendees, there is a poll down below on your screen. This is a feedback thing. We have 3 questions in the poll, which will not take much of your time. We encourage you to take the poll. This will help us to set the tone for our upcoming webinar. And that next webinar would be on laws for Hindus, Christians, Muslims, and others, and a case study of dying intestate. So I request all of you, please take the poll. And yeah, at last, Dilzer Consultants, we thank Mr. Suresh for the insightful session.
Thank you.
And to everyone who attended the webinar. Thank you.
Thank you very much, Suresh. Today we got to learn a
Thank
lot
you very
in
much.
regards to will and trust. We look forward to learning more next Saturday, same time, 12 to 1, and we'll dive deep in terms of laws and every requirement that we need. Thank you very much.
Thank you very much. Thank you all. Have a great day.